Yes, Mr. Pretorius.
Thank you, Chair. The next witness is Mr. Clinton Uleman. His statement is before you in Annexure S11, or rather Exhibit S11. There's also a supplement to Exhibit S11, which is really an extract from the annexures to the evidence of Mr. Grizi. It's there purely for convenience, but the page references are all the page references in Mr. Grizi's testimony and statement and annexures. Mr. Uleman was the lead investigator employed by the SIU at the time of the investigation into Bosasa, and he will testify as to the circumstances involved in the SIU investigation, of which we've heard much evidence, the production and presentation of the report.
Okay, thank you. So this is Exhibit S11. Is that a continuation from Mr. Grizi's exhibit?
Yes, the same series of statements.
Same series, okay. Thank you.
May Mr. Uleman be sworn?
Yeah, thank you.
Clinton Uleman. Do not. Yes, I do. Sorry, open door.
Thank you.
My apologies, Chair. Prevention is better than cure.
Yes, Mr. Pretorius.
Switch my telephones off.
You may proceed.
Thank you.
Thank you.
Mr. Uleman, you are at present an investigator in private practice.
That is correct.
During 2005 to 2012, what position did you hold?
I was employed by the Special Investigating Unit, the SIU, and I initially started off there as a Chief Forensic Investigator. By the time I left in 2012, I was a National Program Manager.
And it's in relation to that employment that you have prepared this affidavit for the benefit of the Commission.
That is correct, Chair.
If you would go please to page 12 of Exhibit S11, please.
Sorry, is it page 12 of?
Exhibit S11, your statement,
Yes.
or affidavit. Is that your signature there?
It is indeed, yes.
You attested to this affidavit that you are now presenting to the Commission yesterday on the 31st of March.
That is correct, Chair.
In fact, last night.
Yes.
And the statement or affidavit from pages 1 to 12, is that your affidavit?
It is, yes.
Are you happy that the contents of that affidavit are true and correct?
I am, Chair.
The annexures to the affidavit, if we could perhaps identify them now, at pages 15 and following, annexure CO1, what is that document?
It is an affidavit that I attested to, which accompanied the SIU report.
Is everyone able to hear at the back? I think you may have to raise your voice, Mr. Alderman.
Sure.
Thank you.
Perhaps if you could speak a little closer to the microphone. Thank you. So you say page 15 is an affidavit made by yourself. For what purpose?
It was a covering affidavit for the submission of the SIU report.
And the SIU report, as I understand it, is contained in the pages that follow.
That is correct, yes.
And then if you go to CO2, what is that document?
This is an answering affidavit, which I deposed to, which related to a legal challenge that BSASA brought against the SIU to prevent the proceeding of the investigation.
Yes.
In fact, they filed an interdict.
I understand that you've annexed this affidavit for the purposes of presenting a complete record of relevant documentation to the Chair, but we won't refer to that in any detail.
That is correct, yes.
You will, however, talk of the challenge brought by BSASA to the investigation and its effect on the investigation.
Yes, that is correct.
And then Annexure CO3, again included for the purposes of completing the record of evidence rather than for any detailed examination by yourself. What is that document?
This is the charge sheet from the Regional Division of the North Gauteng High Court, which relates to the recent charging of members of BSASA and the affiliated companies, as well as members of the correctional services for offences which were ostensibly related to the SIU report.
And you will tell the Chair...
One second, Mr. Pretorius. From my side, it doesn't look like there is much difference between how you were speaking before and how you are speaking now. I don't know whether those at the back hear you better now or not. They will indicate to me if they can hear you now.
Sorry, am I audible, Chair? Or
I think you are audible. Is Mr. Pretorius audible? Yes. But there's still a challenge with regard to the witness. Yes, I think you have to raise your voice. You know, some people naturally have voices that are quite soft, so you just have to raise your voice.
I'll endeavour to raise my voice, Chair.
Okay. Thank you.
The charge sheet at pages 213 and following is the charge sheet related to the recent arrests of BSASA or ex-BSASA officials and ex-officials of the Department of Correctional Services.
That is correct.
And you are able to say, I understand, where you're able to give evidence in relation to the origin of the allegations, at least, in relation to that charge sheet. We'll come to that in due course.
Yes, that is correct.
You say, Mr. Ullerman, that you were the lead investigator in the investigations conducted by the SIU in relation to allegations made concerning BSASA on the one hand and the Department of Correctional Services on the other. It's perhaps a legal or technical point, but it will become important, certainly in your evidence and perhaps later as well. How does the SIU operate, and on what basis would it conduct an investigation?
So the SIU their investigation powers come from proclamation from the President. So a motivation is submitted for an investigation. It is submitted to the Presidency through a process where it goes through the Department of Justice. Once the terms of reference have been agreed, the President will issue a proclamation, and that then sets out the terms of reference for the investigation and authorizes the investigation going forward. It also sets the parameters of the investigation. So, for example, if the SIU if the proclamation says the SIU has to investigate ABC, then you have to investigate ABC and not anything beyond that.
And there was, in fact, a proclamation that authorized the investigation into matters related to BASASA and correctional services.
Yes, indeed.
The proclamation did, in fact, limit the investigation, as I understand it.
Yes, that is correct.
What were the parameters of the investigation that you were authorized to conduct?
So with this particular investigation, it related to 4 tenders at the Department of Correctional Services. They are commonly referred to as the kitchens tender, the access control tender, the fencing tender, and the television tender.
We've heard evidence in regard to those 4 tenders, and we will talk about them in your evidence as well, particularly insofar as they're referred to in the SIU report, prepared to a large extent, at least under your auspices.
That is correct. Can I just sort of be clear? So we were an investigation team that was put together by the SIU to investigate this. We were approximately 6 to 8 investigators that were investigating these tenders. I was the lead investigator, and I obviously reported to my principals, which included the deputy head and the head of the SIU at the time.
Now, you've been provided with a copy of the SIU report,
Yes.
and you've told the Chair that that is Annexure CO1 to your statement.
Yes, that is correct.
That document differs in some respects from the document obtained by Mr. Agrizzi and presented in evidence by Mr. Agrizzi. It's not that what Mr. Agrizzi presented is incorrect or fabricated in any way. He presented the report. You've seen that report.
I have seen it, yes.
There are certain minor differences, page omissions and the like.
That is correct, yes.
The report that was prepared under your auspices, when did the investigations commence?
To the best of my recollection, they commenced around about 2007, where they commenced in earnest. Obviously, in the early stages of the investigation, there was a lot of intelligence gathering before the investigation proceeded, and then as soon as the proclamation was published, then the investigation commenced in earnest.
All right, because the first proclamation you refer to in paragraph 2 is dated 19 November 2004. Do you see that?
Yes.
It was extended by further proclamation dated 28 November 2007.
Yes. So
what happened between 2004 and 2007?
So there were previous proclamations for the issued for investigations at the Department of Correctional Services. Those previous proclamations did not cover the BASASA allegations. That necessitated an additional proclamation to be issued to cover these specific allegations which related to BASASA. So that's why I said when we started receiving the allegations, that then formed the basis of the motivation for the last proclamation, and then the investigation began in earnest from there.
So do I understand you correctly, the proclamation relevant to the 4 tenders involving the relationship between BASASA and correctional services, the relevant proclamation is the 2007 proclamation?
That is correct.
And you say it is then that your investigations commenced?
Correct.
You commenced your investigations then in 2004, at the end of 2004, November.
Yes.
And
2007.
sorry, 2007, November 2007. My error.
Correct, yes.
Sorry. How long did your investigation take?
We continued our investigation until we issued our report, which was in 2009.
So it took the SIU, under your watch, to 2 years to produce a report, which, in your opinion, and we'll deal with the detail later, warranted a final investigation and prosecution.
Correct, that's right.
You say in paragraph 3 that the report was submitted to the department. I presume that's the Department of Correctional Services.
Yes, that is correct.
And you submitted the report to the Department of Correctional Services mid to late 2009, you say?
That is correct, Chair.
What was the nature of the response, to your knowledge, from the Department of Correctional Services? We'll deal with the NPA, the National Prosecuting Authority's response separately and what occurred there.
Yeah.
But for the moment, I'm concerned about the response or lack of response from the Department of Correctional Services when they received the report.
Well, we issued the report to the department, and to the best of my knowledge, first of all, the report made a number of conclusions and recommendations, as you're aware. I'm not aware, apart from Patrick Gillingham, disciplinary proceedings being instituted against Patrick Gillingham, I'm not aware of any further recommendations that were implemented by the department subsequent to us issuing the report. I left the SIU in 2012, so I'm not sure whether there would be any further actioning of the report. However, that would be 3 years after we'd issued the report in any event, so that would be quite a long time after that.
Yes. I understand that you, and this is hearsay on your part, but will be confirmed by other evidence in due course. I understand that you've since received reports, at least, that the contractual relationships between BASASA and the Department of Correctional Services continued, notwithstanding the submission to them of the report.
That is correct, yes.
And you've also received reports that in some cases contracts were extended, notwithstanding the submission of the report to them.
Those are the reports that I received, yes, correct.
Yes, and those will be dealt with in further evidence, Chair.
There are police officers who are wearing hats here. They must take them off, please. Thank you.
Now, you've told the Chair that the terms of the proclamation are restrictive in the sense that they define how far you can go in your investigation and you cannot go beyond.
Yes, that is correct.
When you did your investigation, did you come across indications of wrongdoing other than those defined in your proclamation?
Yes, we did.
Were these indications, and let's define them or refer to them for the moment just as indications, were these indications of wrongdoing involving BASASA and other government departments?
That is correct, yes.
What other government departments?
We received allegations that there were similar tender irregularities that had occurred at the Department of Home Affairs and at AXA at the airports.
And the extent of the wrongdoing indicated in relation to Home Affairs, were they significant?
The allegations were significant. We weren't able to test the allegations because they fell outside of our proclamation. So we were aware of them, but we weren't able to pursue it under that particular proclamation.
And the extent, or possible extent? Significant, minor?
Significant, yes.
Right. And had there been an additional proclamation, would the SIU have found grounds for further investigation?
I believe under those allegations that were reported to us, there would have been, yes.
In the event, however, there was no additional proclamation issued to allow the SIU to go further in its investigations.
That is correct. Yes.
Your investigations were expressly limited by the proclamation to 4 tenders.
That is correct, yes.
Right. You've been provided with documentation which in turn was provided to the Commission, including an SIU report or a copy of an SIU report attached to the affidavit of Mr. Agrizi.
Yes, that is correct.
And if you refer to the supplement to Exhibit S11, from page 278 to 344. These are the page numbers, Chair, in the annexures to Mr. Agrizi's affidavit in the Agrizi bundle.
What's the page, what page in the bundle?
It's the supplementary bundle. It's AA, standing for Angelo Agrizi. These are the page numbers in the Agrizi affidavit, as we agreed last with a previous witness. This is the way we would manage it.
Yes, no, I'm
278?
asking 278.
Yes. To 344.
Okay, thank you.
You've had a chance to go through that documentation. In other words, the document annexed to the affidavit of Mr. Agrizi.
Yes, I have.
Can you confirm whether the document which Mr. Agrizi referred to is in fact, in substance at least, the SIU report which you managed and ultimately issued?
Yes, that is correct. Apart from a few pages that are missing in between.
Yes,
But
well,
yes,
let's
that is the
deal
report.
with the differences. The cover page of the report, I believe, is different.
Hang on, Mr. Pretorius. I thought I was there. I thought you said page 278,
Yes.
where I would find those pages.
Chair, do you have, my apologies because
Or is it
perhaps
just
I didn't make myself clear. I'm referring now to the
supplement to
Supplement.
Exhibit S11?
to S11.
Okay, well, it was
And-
just put in the wrong place. Okay,
And Annexure J in that Exhibit S11
yes. Okay, now I found it.
is AA 278.
Yes.
Right. You have the same document in front of you, the
I do.
Warabine document.
I do, yes, Chair.
That is the document which Mr. Agrizi produced.
Yes.
He said that that is or was the SIU report. Correct? You must.
Yes, I can confirm that is correct.
And you have confirmed to the Chair it is indeed the SIU report. So Mr. Agrizi's evidence in that regard is corroborated by you.
Correct.
You say, however, there are some differences. They may not be material differences, but omitted from Mr. Agrizi's version of the report, we can ignore the cover page being different for the moment, or page X of the report.
Yes.
Where is that in your bundle? In Annexure CO1. It's Roman numeral 10.
28, yes.
That distribution list was not included in the copy that Mr. Agrizi obtained.
Yes.
And then page 49 to 75, you say that those pages too were not contained in the document that Mr. Griti had.
Yes, from the document provided to me, that's what I found.
But other than that, it's the same document for all intents and purposes.
That is correct, yes.
In paragraph 5, you give some detail of the distribution list that was omitted from Mr. Griti's report. That merely shows the persons to whom the SIU report was distributed. Am I correct?
That is correct, yes.
That same page contains a confidentiality clause, which makes it very clear that this SIU report could not properly be distributed to anybody else other than the persons mentioned in paragraph 5. That's the Minister of Correctional Services, the Acting National Commissioner of Correctional Services, the head of the Special Investigating Unit, the Special Investigating Unit Program Manager, and the SIU Archive. Those were the only authorized recipients of the report.
Correct, yes.
So if that report came into the hands of BASASA at any stage, that would have been entirely unlawful.
Correct.
Do you know how the report came to be in the possession of Mr. Griti?
I'm not aware.
And do you know how it became available to other members of the public?
No, I'm not aware.
Did the SIU, officially at least, and I'm not talking about leaks now, clearly there was a leak,
Yeah.
but did the SIU distribute the report to any other entity or individual?
No, the SIU did not.
Are you able to say from your own knowledge, at least on the basis of probabilities, whether the report was leaked improperly?
I believe it was improperly leaked, yes, Chair.
And you refer in paragraph 6 to Regulation 4 of the Special Investigating Units and Special Tribunals regulations, which oblige SIU members to keep information, including the report, I presume, confidential,
Absolutely, yes.
and which make it an offence to breach that requirement of confidentiality.
That is correct.
You give evidence in paragraph 6.2 of an incident which indicates that the report was in fact unlawfully leaked.
Yes.
What happened on that occasion?
It was within a day or two after we had delivered the report to the Department of Correctional Services that I received a call on my cell phone from a journalist who indicated to me that he had a source within BUSASA, and the source had informed him that our report, the SIU report, was at BUSASA and was being discussed by the executives at BUSASA. I questioned him a little bit further, but he didn't want to divulge too much more information to me.
So you say within a day or within 2 days?
It was within a day or two. It was,
Yes.
yes, that is correct, Chair.
So to summarize, the regulations surrounding the confidentiality of SIU reports and their distribution are quite strict.
Absolutely, yes.
It's a criminal offence to breach those provisions regarding regarding confidentiality.
Yes, it is.
And you say, as far as you were aware, as the person responsible for the compilation and presentation of the report was issued only to the 5 recipients named in your evidence,
Yes,
but that within 1 or 2 days, BASASA already had, according to a report received by you, a copy of the report.
yes, that is correct.
And we know that from the evidence of Mr. Griti as well.
Yes.
What measures were in place what measures were taken by the SIU to try and make sure that it would be very difficult for anybody who had received, among those recipients who had received the report, to give it to any unauthorized person?
Well, I can tell you at the time, Chair, the entire investigation team that was dealing with Bosasa was separated from the rest of the SIU. We were placed in a separate part of the building. We weren't allowed to discuss the matter with any of our colleagues. It was, being the sensitive matter that it was, we reported directly to our principals, the deputy head and head of the unit, and information, sharing of information was very restricted. Even the documents that were printed, we knew how many copies were printed, how many versions there were. So when they were disseminated in a particular order and only to those who needed to have copies of the report. The report that was given to the Department of Correctional Services was a hard copy report. We didn't give them an electronic copy. So it was a hard copy report that was delivered to the Office of the Correctional Services in the city centre of Pretoria.
When you talk about a report that was given to the Department of Correctional Services, you're talking about the one that was given to the acting national commissioner at the time?
That is correct, yes.
So one copy was given to the Minister of Correctional Services, and then another copy was given to the acting national commissioner?
Yes.
Okay. Would there have been any warnings or discussions with the recipients as to how much care they needed to take to make sure that the report didn't land in the hands of unauthorized persons?
Yes, indeed. In fact, in the weeks that, in the build-up to us delivering the report, we had a few meetings with them where we emphasized the importance, because the matter was so sensitive and because of the legal challenges that we were facing from Bosasa, we didn't want the report to be leaked. So even before we had actually delivered the report to them, during those meetings, we emphasized the importance of making sure that it is kept secure at all times.
Chair, I'm not sure what the intention is, given the late start, in regard to the short adjournment.
Maybe we should take a tea break at 12. How does that sound?
It's fine. Thank you, Chair.
Yeah, let's take the tea break at 12.
Now, you say in paragraph 7...
One second. Thank you.
You say in paragraph 7, Mr. Uleman, that the SIU report contained, as we know and as we will confirm later, allegations of a number of irregularities in respect of the contracts that you were asked to investigate. It also contained evidence of payments, gratification or bribes paid for the benefit of Mr. MT and Mr. Gillingham.
Correct.
As a result of those findings set out in the report, what steps did the SIU take?
Because we'd found evidence of a commission of an offence, the SIU is obliged to report such conduct to the National Prosecuting Authority. The relevant prosecuting authority is how the Act refers to it, which is what we did. We had a meeting with the members of the MPA, and we handed over a copy of our report to them, in which these allegations and our evidence is contained. So it was a report with all the annexes, which set out the basis for the evidence which we had gathered.
One of the issues that the Commission is concerned with and is investigating is whether there was undue delay or a lack of interest on the part of the National Prosecuting Authority in dealing with the necessary steps to be taken following on the receipt of your report.
Right.
I'll ask you questions about that issue or those issues in due course. But for the moment, by way of background, please explain to the Chair the role of the SIU in investigating matters that you're obliged to in terms of proclamations, and the role of a law enforcement authority such as the NPA on receipt of your report.
Right.
Who must do what?
So the SIU will investigate a matter in terms of the proclamation, where we find evidence of criminality, evidence which points to a crime being committed, an offence being committed. The Act says where practically possible, it must hand over that evidence and report it to the relevant prosecuting authority. So the SIU is not a law enforcement agency as such where they investigate crime. Their focus is on maladministration and civil recoveries for departments, etc. So, as I said, where we find evidence of criminality, that then gets reported to, and the evidence gathered during the course of our investigation handed over to the National Prosecuting Authority for actioning. The Act is quite specific. It doesn't say that we must hand it over to the police. It says we must hand it over to the relevant prosecuting authority.
Right. So the role of the relevant prosecuting authority on receipt of your report would be what, in order to found and complete a criminal prosecution?
Well, they would then have to action it through the police, and a criminal case would need to be registered, a complainant statement obtained, and a docket registered in order for the criminal investigation to proceed.
During the investigation that was conducted under your auspices by the SIU, did certain litigation take place?
Yes, it did.
You refer to that in paragraph 8. Would you tell the Chair about that, please?
Yes.
Maybe before you do that, let's. When you were investigating, I assume you would have taken statements from certain witnesses.
Yes, that is correct. Yes.
And you would have gathered various documents in the course of your investigation. When you had completed your investigation and had prepared your report and you submitted it to the NPA, did you also submit whatever supporting documents and statements that you would have taken in the course of your investigation over to the NPA so that they had full benefit of what of the documentation and statements on the basis of which you had prepared the report?
Yes, we did, Chair. Initially, we handed over the report, and then with the annexures. Then there were subsequent meetings held between the investigating team and members of the NPA. In fact, we did a number of presentations to them where we set out the evidence, how we'd gather the evidence, and how we'd reach the conclusions that we had reached, which are contained in the report. And then from there, we began to hand over all the evidence that we had in our possession.
So you ultimately handed over all the evidence that you
Correct.
had gathered?
Yes.
Okay, thank you. You were about to answer a question that Mr. Pretorius put to you. If you still remember it,
Yes.
please answer it.
No, I'm fine. Thank you, Chair.
Oh, yes.
Yes. BOSASA had sought by way of approaching the High Court to interdict the SIU investigation, to stop the investigation, in fact, to limit the scope completely. And that led to us curtailing the investigation, if I can put it in that way. We eventually reached an agreement. The SIU committed to not continue with the investigation and interview material witnesses and take affidavits from material witnesses whilst these interdict proceedings were on the go. That obviously led to the scope of the investigation being limited quite significantly.
All right. Before we deal with that issue, Annexure CO2 is the answering affidavit that you filed on behalf of the SIU in relation to that interdict.
That is correct, yes.
Right. We needn't. It, for the sake of completeness, sets out your official response to the allegations in the interdict.
That is correct.
You say that nevertheless there was an agreement reached pursuant to the application that effectively limited the scope of the investigation.
That is correct.
Did the agreement also preclude you from interviewing certain witnesses?
Yes, that was part of the agreement, is that we would not proceed to investigate, interview senior execs at Bosasa and their related companies, pending the outcome of this application.
The effects of the agreement, and in turn the effect of the application, is summarized in the SIU report.
That is correct. Yes.
Under the head limitations. Would you just show us where that is contained, please? So at page 12, CO, your pagination 49.
Yes, that is correct. It's listed as paragraph 4 or section 4, limitation of the investigation, and then it sets out the agreement that was reached, as well as the impact on the investigation and the limitations that resulted from it.
Why was an agreement reached?
I'm not sure.
Why was the matter not defended in order to allow you the full scope of your investigation?
Well, to the best of my knowledge, the SIU was defending it, but in order for us to be able to finalize the investigation as it was at the time, we agreed to not to proceed with these interviews and further investigations.
So as I understand it, the Bosasa sought an interdict.
Correct.
And it, in all probability, sought an interim interdict pending finalization of the application.
That is correct, yes.
Which would have rendered you absolutely inactive.
That's right, yes.
And so in order to allow you to continue your investigation pending the final outcome of the application, an agreement was reached which limited the investigation.
That is correct, yes.
Was the litigation ever finalized?
At the time when I left in 2012, I'm not sure whether it had been finalized yet or not. But the fact is, we actually released our report as it stood then. So I would imagine it made those proceedings moot. We'd issued our report.
Yes, but your investigation, your continued investigation and your report, as I understand it, would have been limited not only by the terms of the proclamation,
but also by
limited, but also by the extent and contents of the agreement entered into subject to the litigation.
Very much so, yes.
Right. Why don't you place on record or read onto record paragraph 4 then on page 49.
Sure. All right, it says the heading is limitation on the investigation. The report is based on the review and analysis of documentary and electronic evidence, interviews conducted, and affidavits obtained by the SIU. The investigation, however, was constrained by litigation, as explained hereunder. Bosasa has sought by way of application proceedings in the North Gauteng Division of the High Court of South Africa to interdict the SIU from investigating the full scope of Bosasa activities regarding the awarding of the 4 tenders to it by the DCS. As a result of the application, the SIU gave an undertaking not to interrogate material witnesses pending the finalization of action proceedings for a final order. The SIU has accordingly not interrogated Bosasa's officials, its auditors, and other witnesses who could impart material information regarding issues relating to the investigation. The investigation has accordingly not been as intensive as the SIU would have wanted, and accordingly any lacuna that exist in the investigation will be addressed upon resolution of the litigation between the SIU and Bosasa.
The charge sheet, which is the third annexure to your affidavit,
yes,
charges related to intended prosecutions of Bosasa officials and the arrests made this year after Mr. Agriti has given evidence. Does that charge sheet range much further beyond the limitations of your report?
There are differences. I can see there are areas where additional charges or investigation has been done, but substantially or in the main it is based on the evidence that was uncovered during our investigation.
Well, you were the lead investigator of the team that investigated these 4 tenders.
Yes, I was, Chair.
Before an undertaking was given on behalf of the SIU to Bosasa in that litigation, that you would, or the SIU would refrain from interviewing certain witnesses. Were you given an opportunity to express your view whether that agreement or undertaking should be given or not?
Yes, we were, Chair. I mean, the decisions were ultimately made by our principals on the advice of counsel as well. So we had meetings with counsel as well.
Yeah.
Obviously, as an investigator, we would never like to be curtailed in our investigations. But the decision that was taken at the time, in order for us to complete the investigation as it stood, I think was the correct decision at the time.
It's just that it sounds very strange that the SIU agreed that it would not, pending the outcome of, or was it pending the outcome of that application, it would not investigate, it would not interview material witnesses, because that's the phrase used, material witnesses.
That is correct.
In relation to these tenders. So I thought that the Bosasa may have approached the court on the basis that you were investigating matters that were outside of your scope as set out in the proclamation. But from what one reads here, it was, they didn't want you to interview witnesses whom you regarded as material. Obviously, they thought they were material too, otherwise why would they go to court to prevent you from talking to them? That they were material in relation to the same tenders.
Yeah.
So I'm wondering why the SIU agreed to that.
Yeah, it's not a question
You
I can
might
answer.
be able to
Yeah.
assist, you might not be able,
Yeah.
but I would have thought that having been the lead investigator, you would have wanted to make sure that you understand what the reasoning is
Yeah.
from those who might have been saying, let us give this undertaking.
Yeah. Look, as I said, I mean, I was included in the discussions, and with our principals at the time, as well as the meetings with counsel, and I mean, the legal challenge was on a number of aspects. It related to,
Yes.
it went as far as even the proclamation, the motivation for the proclamation. So
Yeah.
it was a multifaceted challenge.
Yes.
But in order for us to be able to at least continue with the investigation, and rather than be left or rendered stranded in terms of where the investigation would just stop, I think that was the motivation to continue with the investigation. And I think also the intention was, once these legal issues were resolved, to then interview these material witnesses and to continue from there. However, after we issued the report and there was evidence of criminal offences being committed, it was then obviously also the National Prosecuting Authority and the police that needed to come on board to conduct those investigations further.
But you say you were never subsequently involved in any investigation that would have included interviewing these so-called material witnesses that you had been prevented from interviewing?
No, I was not. No.
Yeah. But one gets the impression, therefore, that your investigation, as represented by the report that you gave, wasn't complete, or wouldn't be said to be complete until you had interviewed those material witnesses. Is that right?
Understood, Chair, and
Yes.
you're quite right, yes.
Yes. But that didn't mean that there were no persons who could be charged. Is that right?
No, it did not mean that at all. I mean,
Yes.
there was significant evidence.
Yeah. There was adequate evidence for at least some of the people
Yes.
to be charged.
Yes, and I think that was part of the motivation to go that route as well, in that we'd already uncovered evidence of criminality. And then to finalize the report in such a way that that evidence could then be exposed and handed over to the National Prosecuting Authority.
Yes.
That would then further investigate. That would then further the investigation.
Yes.
Because obviously, I mean, the police and the prosecuting authority have a different mandate to the SIU.
Yes.
So where there's evidence of criminality or crimes that are reported, they're obliged to investigate that. So that motivation sort of strengthened the argument to say, well, we have evidence of criminality. We have evidence of numerous irregularities involving many of the members of the BASASA group, as well as correctional services officials. And on that basis, we wanted to finalize the report and hand it over.
Is your recollection that part of the motivation for giving the undertaking that was given on behalf of the SIU to BASASA was that the evidence that you had uncovered already was such that charges could be brought against certain people, and that later on, if need be, the investigation could be taken further, but in the meantime, some criminal proceedings could start?
That is correct, Chair, yes.
Yeah.
We had gathered evidence, as I say, which we felt was strong enough for criminal
Yes.
charges to be brought, or at
Yes.
least properly investigated through
Yeah.
the NPA and the SAPS.
Okay, thank you.
Just to summarize then, the scope of the litigation, and particularly the application that was brought for an interim interdict pending the grant of a final interdict,
Yes,
included a challenge to the validity of the proclamation authorizing the investigation.
that is correct. Yes.
What was sought was a final interdict, but pending the finalization of the application, an interim interdict which would have stopped the investigation completely.
That is correct, yes.
And for better or worse, a compromise was reached which allowed you to continue the investigation subject to certain restrictions.
That is correct, yes.
As an investigator, how did you and your team feel about being restricted in this way? What was your view in relation to your intention to investigate these issues?
Well, as I indicated earlier, as an investigator, you always want to be able to investigate the matter fully. To be curtailed in any way is frustrating, to say the least, yes. But as I said,
you already told the Chair that the investigations relevant to BASASA and the Department of Correctional Services could have been extended to include other departments, but that proclamation never came.
No, but in fairness, I have to say that that would have required some work to be done as well. There would have to be an assessment of the allegations, motivation for the proclamation, and then then it's up to the presidency and the president to issue the proclamation based on the motivation that was submitted by the SIU.
Yes, but whether it would have involved work or not, the point is that work wasn't done.
Yes,
So the request to the president for another proclamation or for one that extended the scope of the proclamation that had been issued was not made. In other words, the request was not made,
yes,
and not that the request was made, but the proclamation was not issued.
yes. No, I'm not aware of any additional request for proclamations, Chair.
Okay, all right.
Let's deal for a moment with the draft charge sheet. And that is the charge sheet served this year. It appears at page 213. And the questions I will ask you really deal with the extent to which that charge sheet is based on an investigation or facts gleaned from an investigation conducted some 10 years earlier. If you would go, please, to Annexure CO3 at page 213.
Yes.
Firstly, you will see there that the accused are Messrs. MT and Gillingham, Mr. Greasy, Mr. Fantonda, and certain companies that we know to be part of the Bosasa group of companies.
That is correct, yes.
Mr. Greasy and Mr. Fantonda were officials of Bosasa who gave evidence. Is that correct?
That is correct, yes.
And Mr. MT and Gillingham, we know well now, were officials at one stage of the Department of Correctional Services.
Correct, yes.
The first comment that bears mention is the absence of other Bosasa officials from the list of accused. Do you have any explanation for that?
No, I do not.
Were other officials other than Mr. Greasy and Fantonda mentioned in the SIU report? One example, Mr. Gavin Watson.
No, he's not mentioned in our report, no.
Why not?
We never had the opportunity to interview him or anything like that.
So was he one of the persons that you were precluded from interviewing?
Yes, he was.
Pursuant to the litigation?
Yes, he was.
Well, if I recall correctly, Mr. Akrizi has given evidence to the effect that, and I'm putting this in my own words, Mr. Gavin Watson was kind of boasting that his name was not mentioned anywhere in the SIU report.
Yes.
I'm not sure whether Mr. Akriz was saying that Mr. Gavin Watson said this already before the report came out, or whether it was after. You may or may not have heard Mr. Akriz say that, but you are confirming that his name was not mentioned there, but you say the reason why that happened was because because Bosasa brought an interdict application in the High Court, and part of it was that he and certain other people should not be interviewed by yourselves.
Yes, that is correct, Chair. I can confirm that his name's not mentioned in the report, but the reason for that is because of the agreement that we reached. It wasn't only him, there were other executives that we would have wanted to have interviewed as well as part of the ongoing investigation.
Well, the other witnesses that you interviewed, didn't they implicate him?
Well, as part of the investigation, that is what we wanted to test. So we received some information which indicated that Mr. Watson was aware of what was going on at all times, and was in fact at the forefront of the irregularities that had been identified. We never had the opportunity to test these allegations with him or present evidence to him or anything like that.
Yes, but that was because he didn't want to be interviewed.
Yes, I imagine
so
he didn't.
If you had
yes.
enough evidence from other people, why couldn't his name be put there, that you have got evidence that he did certain things, if that's the evidence you had, which were potentially of a criminal nature? Was that not done? Because it's not like you couldn't find him. He didn't want to be interviewed, from what yes. I understand the Bosasa application
yes.
meant.
So if I can just place it into context, the evidence that we got was often hearsay evidence. People would say, and I think one of what we were informed was that you would never find Mr. Watson's signature on a document. You would never find an email that he had sent or anything like that. He tried to keep his nose clean or out of the document chain and things like that. In fact, one of the persons we interviewed said he doesn't even think that Mr. Watson's computer is ever used, the one that's in his office. So he said, based on that, you won't find direct evidence linking him to something. So the evidence that we had needed to be investigated further before we could approach Mr. Watson with and interview him directly.
So are you saying that you didn't have enough evidence to put his name in the report? Is that what you're saying?
At the time of the issuing of the report, yes. And that is why we wanted to investigate matters further.
Okay.
So I understand your answers to questions from the chair. Your evidence, at least, raises two issues. Firstly, the extent to which you ultimately could interview witnesses and obtain evidence from them.
Yes.
And secondly, the extent to which documentation which you obtained in the course of your investigation implicated persons such as Mr. Watson and Mr. Watson himself.
Correct, yes.
And you say you could find no documentary evidence implicating Mr. Watson.
At the time that we had issued the report, yes, that's where we stood.
And the matter was complicated further by server's crash and the apparent attempt to destroy documentation about which you will testify in due course.
Yes.
The differences between the findings in the report on the one hand and the charges, the content of the charges laid this year against the persons that we've just referred to may become relevant in our further investigations and are matters that need to be looked at more closely by the investigators and the legal team. So it's necessary, therefore, briefly just to highlight what the charge sheet contains that the SIU report did not contain.
Right.
Well, Mr. Ollerman, your evidence is that when you look at those charges in respect of Mr. Agrizi and others who were arrested after Mr. Agrizi had given evidence here, when you look at those charges, substantially they relate to the SIU report that you prepared. Is that right?
That is correct, yes, Chair.
Is my understanding of your evidence correct that there is very little that seems from those charges not to be related to the SIU report that you prepared? Before you answer that question, just make sure that you satisfy yourself that,
yes,
because it is quite important, because I caused a representative of the Commission to try and establish what gave rise to the arrest of persons who were busy assisting the Commission, including Mr. Agrizi, and the timing of the arrest. And I was informed that the SIU said that the arrest was not based on the evidence that was given here or the SIU report that was completed in 2009, and that it related to some other report. So I wonder to what extent whether your evidence actually suggests that what may have been told to me or may have been told to a representative of the Commission, which he conveyed to me, might not have been correct. So I go back to my question.
No, I understand.
Are you in a position to say there is very little when you look at the charge sheet? There is very little that really doesn't relate to the report, to the SIU report that you prepared?
I wouldn't say very little, Chair. What I'll say is that from what I can see going through the chart sheet and looking at what we
knowing the contents of the SIU report.
Absolutely.
Yeah.
A large proportion in the main is what I've said it in my affidavit.
Yes.
Appears to come from the evidence that or the investigation that was done,
yes.
Which culminated in the SIU report. There are various areas where I can see further investigation has been done, and those obviously would not be the basis for.
Yes.
Or the charges would not then be the basis from the SIU report.
Yes, but basically what you are saying is, as far as you can see, knowing the contents of the SIU report and having regard to this charge sheet, you are able to say, in the main, that charge sheet is based on the SIU report. Am I correct? Is that how you see it?
That's how I see it, Chair. That's my opinion. Having seen the chart sheet and having knowledge of the contents of the SIU report, the facts that were investigated and the evidence that was obtained during the investigation is there in the chart sheet.
Yeah, okay.
Just to wrap that up, perhaps we should just refer to paragraph 10.2 and paragraph 10.6 of your analysis of the draft chart sheet.
Yeah.
And there you highlight aspects that were not dealt with in the SIU report.
That is correct, yes.
For the rest, you say substantially the counts not dealt with in those two paragraphs are substantiated in the SIU report.
Correct, yes.
So let's just look at the exceptions then. Paragraph 10.2, you say in count 7 and 8, a charge is leveled which contains information not dealt with in the SIU report, and these charges relate, you say, to payments and gratification to accused number 1, Mr. MT, for flight tickets, car rental services, accommodation and cash payments over the period May 2004 to July 2015.
That's correct, yes.
And the second exception to your general observation is in paragraph 10.6, which relate to charges of money laundering and the payment of 62,796 for travel expenses relating to a trip to Europe undertaken by accused number 2 and Teresa Gillingham.
That is correct, yes.
So those are the only aspects which are not dealt with in full in the SIU report.
Yes, I can also mention paragraph 10.7, where certain information, not all of it, deals with the SIU report. Right. But parts of it are there.
But just looking at your paragraph 10, it looks like it would be fair to say out of 15 counts, 1 to 6, 7, and 8, 9, 10, 11, 12. Out of about 15 counts, only about 2 or 3 on your analysis don't necessarily relate to the SIU report. The rest do relate to it.
That's my analysis of it, Chair. Yes.
Okay.
Arising out of that, I would like to ask you to deal with a question of concern to the legal team, and that is the issue of delay, but perhaps we could deal with that after the short adjournment, Chair.
Yes, okay. We'll take the tea adjournment and we'll resume at 12:15. We adjourn.
All rise.
Before we proceed, Mr. Pretorius, I just want to say something about the lady who sought my attention as I was adjourning. I understand that she's the same lady who called for my attention on one of the days last week, and I indicated then that I was requesting Mr. Pretorius and the legal team to establish what she might have wanted to bring to my attention and the attention of the Commission. I just want to say I have been given a report in regard to the interactions that she has had with the Commission. We continue to encourage everybody who has information that will assist the Commission in regard to the investigation that the Commission is doing. Some of the information people will believe will help us, but maybe when we look at it, we will not think it's as helpful as they think it is. We will continue to encourage people, but we will respect people's views as well when they may have a different view in terms of how useful the information they have will be to the Commission. But it would appear that there may be certain personal circumstances relating to the lady that just need to be respected, and I think I will leave the matter at that. So, yes, thank you. Let's proceed.
Thank you, Chair. Mr. Ullerman, before the short adjournment, you were dealing with your own comparison between the contents of your report and the subject matter of your investigations and the charges that were leveled against certain persons and entities this year after two of the accused in that matter had given evidence before the Commission, namely Mrs. Agresti and Mr. Van Tonder. The SIU report, you say, was completed in 2009.
That is correct, yes.
It would have been handed to the NPA when?
It would have been late 2009 that it was handed to us.
So shortly after its completion.
Correct, yes.
We now have charges brought 10 years later based on at least substantial parts of the SIU report. In fact, mostly based on the SIU report, you've told the Chair.
Yes, correct.
Do you have any explanation as to why there should have been a delay of 10 years between the handing of your report and the level over to the NPA and the leveling of charges? And do you have any comment in that regard?
Look, I have no explanation as to why. I will say this, that the evidence gathered by the SIU was done in terms of its proclamation under a specific piece of legislation, the SIU Act. So the evidence was gathered in terms of the SIU Act. Where we found evidence of an offence, that evidence was handed over to the relevant prosecuting authorities, the NPA and the SAPS. There would be certain procedural issues which would need to be dealt with for the evidence to be admissible in terms of the Criminal Procedure Act. So I could understand that process that would need to be done. But for 10 years, I find it incomprehensible that it would take that long. I'm perhaps giving away my age now, Chair, but I've been involved in forensic investigations for more than 25 years, some very complex, and I've never encountered a criminal investigation of this nature that would take so long.
So you have no difficulty accepting that there may still have been some issues to be attended to before the actual charging of people, but the point you are making is 10 years is just far way too long for those procedural issues to have been attended to.
Correct. In my view, yes, Chair. I mean, and I also accept that there would have been further investigation that would needed to have been done. As you were questioning me earlier, there were certain things that we could not cover in our investigation, which the criminal investigation would ideally have covered. So I accept that some investigation was still to be done. But again, 10 years is, in my mind, is an exceptionally long time for a matter to reach its conclusion.
If we could move on then to the next part of your statement, Mr. Uleman. You've had an opportunity to examine certain other documents provided by Mr. Grizi to this commission and to prepare some comment on those documents.
Yes, that's correct.
These documents, it's apparent from their content, mostly emanate from the National Prosecuting Authority, and they're communications between the Commercial Crimes Unit, which is part of the NPA, and the National Director of Public Prosecutions at the time.
Yes.
And you will indicate how these documents and these comments contained in these documents relate to the SIU investigation of which you've told the Chair.
Yes.
The first is the document that appears in the supplementary bundle. Chair, that is the S11 supplementary bundle at page AA388, Annexure Q3.
Please just repeat the page number.
AA388.
Okay.
This is an email or memorandum from Advocate Glynis Breitenbach to the National Director of Public Prosecutions, Advocate Similani. Would you read its contents onto the record, please?
Sure.
I might interrupt you from time to time as you read it.
Shall I start at Dear Advocate Similani?
Yes.
The so-called Bosasa matter was received in this office directly from the SIU during late November 2009.
That confirms your own evidence.
Correct, yes.
Yes.
As a result, it has been referred to the SAPS in order for them to study the material and take a decision on whether or not to open a case docket. Due to the profile and sensitivity of the matter, I approached Commissioner Hans Meyrum, in brackets, the national head of the commercial branch, close brackets, for assistance in getting the matter allocated to the Office of the Serious Economic Offences of the SAPS. The acting commanding officer allocated the matter to Senior Superintendent DJ Creel for further investigation. Once the material supplied to us has been studied by myself, Advocate I. Grobler and Mr. G. Nkadimeng, the prosecution team, and the investigating officer, we had a follow-up meeting with Mr. Clint Ullerman of the SIU to discuss the material in their possession, but not yet supplied to us, and the admissibility thereof. Mr. Ullerman supplied us with copies of the civil litigation conducted between the SIU and Bosasa during late December, which was then studied by all the role players when they all returned from their annual leave in order to determine the impact thereon on the criminal investigation, if any. This was done chiefly with a view to obtaining a clear understanding of the issues involved and to avoid any later problems arising as a result of possible derivative evidence. It was essential to understand the nature of the legal challenge against the SIU before proceeding with the investigation proper.
Just before you go on, you will recall, and there has been evidence that at some stage an argument was raised that the SIU was dealing with evidence which constituted what is recorded as fruit of the poison tree.
Yeah.
And for some reason, as a result of that, the prosecution could not continue. Do you recall that being raised?
I do recall that discussion, yes.
Insofar as that was a real problem, and the legal team is not convinced that that's a correct view of the law at all in our new constitutional dispensation, and not convinced that there was any validity to this fruit of the poison tree argument, which might prevent a prosecution. But that's another matter that we will deal separately with the chair. But it's apparent that with the charges now laid, that argument has been abandoned, and the prosecuting authorities have changed their mind in respect of that.
It would appear so, yes.
Yes. If you could really, we don't have to read the whole document. It's unnecessary to read the whole of the email. Just refer to the summary of the document or the extracts contained in paragraph 11.1 of your affidavit, please.
Sure.
That would be a more efficient way of dealing with the issues
Yes.
arising out of this email.
Shall I read from
Yes,
11?
just read the sub-paragraphs to paragraph 11.1, if you would.
Right. So the so-called Bosasa matter was received in this office directly from the SIU during late November 2009. It is essential to meet with the acting commissioner, since she would be the apposite person to depose to an affidavit to form the founding affidavit on which to base the investigation. The case docket cannot be registered without the affidavit of the complainant. The SIU has not supplied the source documents relating to the report. It is essential to understand whether the documents so obtained by the SIU are admissible and can be used in the criminal investigation. An issue that needs to be addressed on an urgent basis is the position of Mr. Lindam T., who is one of the two main suspects and who currently holds the position of Head of Security 2010 World Cup, and the impact that this investigation, once it gains momentum and attracts the attention of the media, might have. Some guidance in this regard would be greatly appreciated.
Two comments. It appears from the comment contained in this email or memorandum to the National Director of Public Prosecutions that a number of what might be referred to as problems are raised with regard to the conduct of any further investigation and prosecution,
Yes.
including sensitive issues such as that involving Mr. Lindam T. Now, I don't want you necessarily to comment on the merits of these complaints. That's a matter for later consideration.
Yes.
But it is important to note that this document was leaked to Bosasa. This document contained a number of problems raised by persons within the NPA in regard to whether a successful prosecution could be launched.
Yes.
Such information in the hands of a potential accused person, such as officials of Bosasa, what is your comment on its usefulness?
Well, it would be invaluable and highly detrimental to the prosecution. I mean, you're giving them insight into procedural issues of the investigation before before there's a charge sheet that's been issued or anything like that. So you're giving them valuable information which they can use to attack the process, attack the investigation, and attack any subsequent prosecution that may follow from that.
Then, in paragraph 11.2, you refer to the response from Advocate Similani to Advocate Breitenbach, dated the 8th of February 2009. That date might be incorrect. Let's just look at AA 393, if you would.
I think it's 2010. It should be 2010, I see.
That date should be corrected. It's the 8th of February 2010, as you say.
Yes, that's correct.
Not 2009. We will find an appropriate way of correcting the record, Chair.
No, that's fine.
That meets with your approval.
That's fine.
This is the response by the National Director of Public Prosecutions, Advocate Similani, to Advocate Breitenbach's memorandum raising concerns with the prosecution or potential prosecution.
That is correct. That's how I understand it to be.
If you would just read onto the record the extracts contained in your paragraph 11.2.
You and your team must withdraw from the case until I'm advised that the case is registered with the police.
So what is happening here is, in response to Advocate Breitenbach's memorandum, the National Director of Public Prosecutions is simply saying to Advocate Breitenbach, you must withdraw from the case.
That is how I understand it, yes.
There will be evidence that at some stage people were asked to withdraw from the prosecution, the investigation, and they were replaced by other less experienced persons. What is the effect on an investigation and prosecution if people are simply told to withdraw?
Well, in my experience, then everything comes to a halt. Then the momentum that you've gathered with the investigation and the prosecution proceeding is then stopped. And if you have to brief an entirely new team, then they've got to start afresh. Then they've got to get to grips with the matter. If it's a technical or complex matter, and in there are areas of this investigation where it is quite complex, then they would need to be brought on board and study that and make sure that they fully understand it. So you're losing momentum, you're placing yourself on the back foot, and it then means that there are just going to be more delays in taking the matter forward.
If you would continue reading, please.
I would have hoped that by now the SIU itself would provide the required affidavit, since they have the locus standi to investigate.
We'll come to the correctness of that comment in a moment.
I note the point that you are making regarding Mr. MT. It is mischievous in the least. Firstly, there is no police docket or investigation underway. Secondly, by your own admission, there is still an assessment to be made on the value of the information available. How, therefore, you can start speculating and making suggestions regarding any person is beyond belief.
Now, one may draw one's own conclusions, and we may invite the Chair in due course as a legal team to draw certain conclusions in regard to the content and tone of that response. But for the moment, as far as you're concerned, the contents of the quote in paragraph 11.2.2 and perhaps the remainder of the comments that you've quoted. Please tell the Chair whether Advocate Similani was correct in his observations.
I don't believe him to be correct, Chair. I mean, the SIU, as we've discussed at some length earlier, when they have uncovered evidence of criminal conduct or criminal offence, that evidence gets referred to the National Prosecuting Authority. The SIU cannot open a criminal case on matters that it is investigating. There may be matters internally that they could open cases on where they are the complainant. But in this case, the SIU is not the complainant. The complainant is the Department of Correctional Services. are the ones that have been harmed by the criminal offence that was committed. So the affidavit that's being referred to have been deposed to by a senior person in the Department of Correctional Services.
And perhaps they were not made keen to do so, but again, that's a matter that we will deal with on all the evidence in our submissions to the Chair. But is it correct to say that because the SIU has the locus standi to investigate, they must provide the necessary affidavit to commence an investigation by the NPA?
I don't believe that to be
prosecution
correct.
by the NPA. Does that make any sense to you at all?
It does not make sense to me. An affidavit, and I did depose to an affidavit, confirming that this was the report conducted, and that's part of my my bundle. But it was not a complainant affidavit to initiate a criminal case. It was the referral of the evidence of a criminal offence that had been uncovered during the course of our investigation.
And what the relevant legislation that you've referred to in your paragraph 11.3 requires you to do is simply to refer the matter in terms of those sections that you've quoted of the SIU Act.
That is correct,
And
yes.
that was done.
Yes, it was.
Then paragraph 11.4, you deal with another document that, well, before we go there, again, such a letter as was addressed by Advocate Similani to Advocate Breitenbach, if leaked to a potential accused, such as the officials of Bosasa, would that be of any interest to them, to your mind?
Definitely. I mean, it goes back to the previous point that I made. You know, it's ammunition that they could use to attack the investigation. There would be areas where they could pinpoint exactly where to attack the investigation, because they would have insight into the thinking and the strategy that was going on within the investigation and prosecution teams.
The next document you refer to that was attached to the statement of Mr. Agrizzi is a document dated 9 March 2010. The document is or purports to be the minutes of a special extended ministerial meeting, and it appears in the supplementary bundle at AA 396 as Annexure Q5. Do you see that document? It starts at page 397.
Yes, I see it.
It's a meeting held under the auspices of the National Prosecuting Authority and was attended by several persons and chaired by the then Minister of Justice, Minister Khadebe. Do you see that?
I do see that, yes.
And it's a briefing on various matters. It's unfortunately highlighted in a way that obscures much of the content of the important paragraph, which is paragraph 3, which deals with an SIU report to the Minister on the, well, deals with the SIU report in a report by the NPA to the Minister concerning the Bosasa investigation. Would you just deal with the list of attendees, firstly, and secondly, the extracts that you've quoted in paragraph 11.4, if you would read those onto the record, please.
So the attendees were Minister J.T. Radebe, Minister N.N. Mapisa-Nqakula, Advocate M. Similane, and the Secretariat as Mr. T. Tlali and Ms. J. Lipinka.
And the minutes reflect that Advocate Similani gave a presentation in regard to the SIU report to those attendees, including the two ministers, and certain recordals are minuted. Would you read those, please?
Yes. So under my affidavit, paragraph 11.4.1, challenges of the report was outlined, i.e. the constitutionality of the report, in that the evidence was contained in the said report was contaminated. The SIU report cannot hold any water in any court, and that of any presiding officer will not proceed with the report at hand. The SIU investigation was not in line with the proper administration of justice, in inverted commas, without fear, favor, and / prejudice, close inverted commas. Incorrect sections of their mandate were used to find evidence. Statements were not done accordingly to the prescripts. And then the last paragraph says political vendetta / agenda identified.
Over the page.
Manipulation of the public identified in that the report was discussed in Parliament prior to the same being handed over to the relevant exec authority. Media coverage over the report prior to having heard or confirmed any criminality by the mentioned senior officials of the DCS. A predetermined element was identified, as well as the race of both the investigators, SAPS, SIU, and prosecutors, NPA.
Now, let's just deal with those issues, because what Advocate Similani is saying in no uncertain terms to two ministers concerned is that the prospects of a successful prosecution here are absolutely hopeless.
That's how I would read it, yes. Yeah.
He's saying on a number of grounds there is no prospect of any prosecution being successful, and therefore it should, by implication, not proceed.
Correct.
And by further implication, that we will submit ought not to be continued.
Yes.
Let's deal with 1141, the unconstitutionality of the report, in that the evidence contained in the said report was contaminated. Now, you led the investigation. You obtained the evidence. What do you say about that allegation?
I'm not aware of any unconstitutionality that is related to the report. I mean, the evidence was gathered in terms of the SIU Act. It was handled in terms of the SIU. The investigation was conducted within the parameters of the Proclamation and the SIU Act. So I'm not sure what the unconstitutionality refers to.
But even if there were irregularities, the Constitution, as I understand it, does not prevent the leading of evidence, provided certain groundwork is laid for the admission of that evidence.
Correct.
And it seems in that respect, in any event, that there has been a change of mind for some reason or other, and that the prosecution is indeed continuing based on evidence gathered by the SIU.
Yes. Well, it does seem to me that there's been a judgment that's been made on the admissibility of evidence at such an early stage of the investigation, without it actually going through a credible process where it can be properly evaluated.
Yes. The second comment is the SIU report cannot hold any water in any court, and that any presiding officer will not proceed with the report at hand. Is that a fair comment?
I don't believe this to be a fair comment.
And again, to the extent that in March 2010, before any further investigation is conducted, that comment can be made, bears its own response, which we needn't bother you with for the moment, but again, there appears to be a change of mind.
It would appear so, yes.
Then it goes on to say the SIU investigation was not in line with the proper administration of justice without fear, favor, or prejudice. What do you say to that allegation concerning your report?
Well, I don't believe that to be true at all. We were an investigating team. We reported to our principals. We were given a mandate to investigate. We did. We obtained evidence, I believe, legally in terms of the SIU Act. I don't believe we acted outside of the SIU Act or the parameters of the Proclamation. Certainly, before the investigation started, I'd never heard of any of the...
Were you or your team on a witch hunt of any sorts?
Not at all. It wouldn't have been within my power to implement a witch hunt in any case at that stage.
And you say that you worked with a team, but the comments you make would apply to the team which operated under you, I presume.
Correct. And we obviously reported to principals, and throughout the investigation, we took advice on counsel, given the sensitivity of the matter. We took advice from counsel on a number of matters.
And did you act in accordance with that advice?
Yes, we did.
The further allegation is made to the ministers that incorrect sections of the mandate were used to find evidence. Is that correct?
I'm actually not even sure what they're referring to over there, because I mean the SIU Act is clear and the proclamation was clear, and we acted within those boundaries.
So you had a proclamation which, in your view, was in order, and you acted in terms of that proclamation and in accordance with the governing legislation.
Correct. Yes.
And then the final statement there is statements were not done accordingly to the prescripts. Well, apart from the grammar, what do you say about that allegation?
I don't believe that to be correct. I mean, all the affidavits that we obtained were done in accordance with how one would do it legally. Yes.
And then, interestingly, the comment is made by Advocate Similani to the ministers that there is a political vendetta or agenda that had been identified. Were
Yes.
you aware of any such political vendetta or agenda?
I'm not aware of any such.
1145 we'll discuss later. Manipulation of the public identified in that the report was discussed in Parliament prior to the same being handed over to the relevant executive authority. Are you aware of a presentation made by Advocate Hofmeyr to the Parliamentary Portfolio Committee?
Yes, I am. I was present at that presentation.
When was that presentation made, as far as you can recall?
To the best of my knowledge, I believe it to be towards the end of 2009.
Right. Prior to or after the report was sent to the NPA and to the Correctional Services Department?
It would have been prior to it, I think.
And then 1146, media coverage over the report prior to having heard or confirmed any criminality by the mentioned senior officials of the Department of Correctional Services. We know that there were leaks and we know that there were media reports. Did this in any way affect your investigation?
Not at all.
If there is a leak, can this exonerate any accused?
I don't believe that it can.
And then 1147, you quote the following: a predetermined element was identified as well as the race of both the investigators in the South African Police Services and the SIU and prosecutors in the NPA. As far as you were concerned, was race a relevant feature of your investigation?
Not that I'm aware of. In fact, the members of the investigating team encompassed all the races that we have.
So you conclude in paragraph...
I'm sorry, Mr. Pretorius. When one reads, Mr. Alderman, that part of the minutes which says, which relates to race, one gets the impression that there were only 2 investigators. But you have given evidence that your team, if I recall correctly, was about 8 people or thereabout?
About 6 to 8 people.
Yes. And you have just said that it was a diversity of races.
Absolutely, yes.
Yeah. So maybe just to complete that picture, do you want to say there were whites, there were Africans?
Yes,
and
there were whites, Africans, Indians.
Yes.
Yeah, and females, males. Yeah.
Yes.
Yeah.
So
I would suggest that it was a very diverse team, yes.
So to the extent that this might give an impression that there were only 2 investigators of maybe one race, you certainly say that certainly is not in line with the true position.
No, it's factually incorrect.
Yes. And yeah, okay, thank you.
Incorrect maybe being polite. You're free to say what you think.
No, I'm fine with incorrect at the moment. It's fine.
The accusation here being that your investigation was motivated by considerations of racial prejudice.
It would seem that way, yes.
But you say that's politely incorrect.
Yes.
Then your final conclusion is summarized in paragraph 11.5.1. Tell the chair of that, please. Or just, perhaps you can just read your final conclusion onto the record.
I'm not aware of the unconstitutionality of the report, nor any political vendetta, or any of the other issues raised which would prevent a successful prosecution.
Right. Then the next document you deal with is at page 400 to 404 of the supplementary bundle. Would you just deal with the extracts in paragraph 11.6 that you quote there, please?
Okay. It would thus appear as if the SIU received information from various and sometimes unreliable sources and made use of the information either without verifying the facts or failing to point out anomalies to those reading the report. The SIU report would appear to have been drafted in a careless and almost casual fashion. The lack of accuracy and precision with the drafting of the report will give ample opportunity to those seeking fault, or to fault. Sorry.
This is a long email from Ms. de Kock to Advocate Similani, the National Director at the time, and she will give evidence in due course. But insofar as it deals with your report and your work in compiling the report, is it correct that the SIU received information from sometimes unreliable sources and that you made use of information without verifying facts or failing to point out anomalies to those reading the report?
No, I don't believe that to be correct. I mean, throughout an investigation process, one always evaluates the evidence or information that you get. So that is done as a matter of course throughout an investigation, and indeed happened over here. So
you've made clear to the chair that in your investigation you were subject to restrictive conditions which hampered your investigation and its thoroughness.
Yes.
Have you read this full document from Ms. de Kock?
Yes, I have.
Do you regard the issues she raised there as matters which would undermine the validity and quality of your report in a general sense?
Well, yes, it certainly does place the report in a bad light. And again, if someone who was being investigated got their hands on this document, it would be invaluable to them to exactly know what the current situation of the investigation was, the prosecution, where the likely successful challenge to the prosecution would be.
That's the... Do you agree with all the comments in the report in all its detail? And I'm talking about the report of Ms. de Kock.
No, I don't personally agree with the comments that she has made. No.
Yes. We're not going to debate each and every one of the points. That would be an exercise that would take too long and is not entirely to the point that the legal team wishes to raise before the chair. Safe to say, for present purposes at least, that the leaking of such a document to the potential accused and to Bosasa would be most useful to Bosasa.
Yes, and extremely harmful to the prosecution's case.
Anyone who leaked the document to Bosasa at the time must therefore have known, according to your evidence, that it would harm and hamper the prosecution.
I believe so, yes.
Then the next comment that you quote here is the following: the SIU report would appear to have been drafted in a careless and almost casual fashion. The lack of accuracy and precision with the drafting of the report will give ample opportunity to those seeking to fault the prosecution, I presume, it would continue. What do you say about that comment?
Well, I disagree with it. I mean, as I've said before, the SIU report was drafted for the purposes of handing over the evidence of an offence which we had identified for the matter to proceed. I accept that there may have been further investigation that needs to follow. But the purpose of the report was not to hand over a court-ready criminal case docket for charges to be immediately drawn and prosecution to be initiated. The report was to identify the areas where we had uncovered evidence of criminal offences and link the individuals that we had identified as part of that criminal offence, and then for the investigation and prosecution to take its course from there.
The point, however, or the principal point that I understand you to be making in relation to these documents is highlighted in the last paragraph quoted in your paragraph 11.6.2.
Yes.
Here one has the appointed prosecutor saying to the National Director of Public Prosecutions, the lack of accuracy and precision with the drafting of the report will give ample opportunity to those seeking to fault it.
Yes.
Or to fault the prosecution. So the person who leaked this report to Bosasa would presumably have read that and would presumably therefore had known expressly without needing to infer that the mere handing of this document to Bosasa would have undermined the prosecution and unlawfully assisted the accused.
Yeah, absolutely.
You make points you've already made in paragraph 11.7.1, so we can go to the next document, but Chair, it's 1 o'clock, perhaps it's 2 minutes to 1, perhaps we can do that after the adjournment.
Yeah, let's take the lunch adjournment and we will resume at 2. We adjourn.
All right. Doesn't have the bundles yet, and they are almost done. Let me just.
Which bundles?
For the next witness.
Okay, I'll adjourn after.